Вітаємо, пане Сергію.
Вітаю вас, добрий вечір.
Welcome, Serhii. Welcome. Good afternoon. So let us start the second stage of the selection to the High Qualification Commission of Judges of Ukraine, the interview stage. And the interview will be conducted by the full commission. These are Robert Brokhaisen, me, Ivan Mishchenko, Serhii Verlanov, Yuhan Mezentsev, Ted Zavzhechny, and Steven Markman. The rapporteurs at your interview are Robert Brokhaisen and me. If for any reason our interview is interrupted, we will definitely reach you and hold it on some other day at some other time. The essence of the interview. The commissioners will ask you questions. The request is to give concise answers to the core of the matter, and the commissioners will be entitled to limit the time of your answer to this or that question. Before we start our interview, you will have a chance to make a presentation of yourself, to tell about your motivation, why you decided to apply for the HQCJ, and to tell about your ideas on the possible changes in the judiciary, or generally your ideas about the judiciary. You choose. And let me give the floor to my colleague, Robert.
Yes, good afternoon. You now have the possibility to give us a 5 minutes explanation why you participated in this competition. Maybe first you introduce yourself and your background to us, and then explain your motivation. Please go ahead.
He's got the translation with some retardation. I don't know, for some reason there is a delay in the interpretation with me. I mean, it goes 2 times. I hear 2 rounds of interpretation for technical reasons. Well, the delay can be there. That may be connected to the internet connection. But actually, there must be some doubling there if he hears it for 2 times. Yes, you have the echo. I can hear you online, and then I hear you for the second time. Well, I'm sorry for those technical reasons, so let's arrange a technical break. Please don't start as yet. We will try to fix it. So, Serhii, I hope that you have clarified this issue. Yes. Everything is fine. So please, let's start, and we would like to listen to your introductory speech. Thank you. Welcome to the members of the Commission and to the audience, and let me tell a couple of words about my professional work experience, and then I will tell you about my motivation. So I started my activity, my work in the prosecutor's office bodies. I was the investigator of the prosecutor's office, assistant prosecutor, and deputy head of the Department of Involvement of Prosecutors in Criminal Proceedings. In spring 1992, I decided to become I decided to become a judge. I undertook the procedure within the fixed timeline, and I was appointed a judge in one of the district courts where I worked for 6 years with no specialization. I had both civil and criminal cases, administrative cases, and cases on administrative offenses. In 2010, I was elected judge of appellate administrative court, and I still work there. Over the period of my work in the appellate court, they elected me 4 times as a delegate to the Congress of Judges, and in 2014-2015 I was a member of the Council of Judges of Ukraine, elected on the basis of the decision of the Congress of Judges in 2014 after the Revolution of Dignity. Now a couple of words on the motivation. I participated twice in the selection to the Supreme Court, and I was acknowledged to be capable of administrating justice in this court, but according to the rating, I did not become the judge of the Supreme Court, which means that I know from my own experience what all the procedures are like. I know both positive and negative elements of these selection procedures. Well, probably I don't know all of them, but I think that I know a lot of them. And I know the stages where some abuse, some manipulations are possible, some subjective pressure is possible in order to make the commission to change the results of the selection. I know the reasons for distrust in the previous composition of the HQCJ, both on the part of the state and on the part of the society and judges themselves. And it's really strange that nobody was satisfied with the work of that previous composition of the HQCJ. But I know what the reason for that lack of trust was. This was lack of transparency, inconsistency, unpredictability of the actions of that HQCJ and the results, unclarity of the results of the selection procedures. I know what the solutions are and what ways we should take to change the situation and to regain trust in the Commission. I think the judges and the society should trust the Commission, but unfortunately there was no trust in the previous composition of the HQCJ. The main tasks and objectives of the HQCJ are to hold selection to the courts of trial instance and transfer of judges. I want the best candidates to win in the competitions and not just the people who are approved from the top. And I want the HQCJ to be an independent body in terms of decision making. And I'm sure that I can become a part of such commission, a member of such commission that will not be subject to any pressure or temptations. And I don't need this position for the sake of position alone. I just am interested in the outcomes of our work. When our generation is leaving this professional career, giving way to the young people, we will have Ukraine left for the next generation. And I want this Ukraine at that point of time to be a member of the EU, of NATO, and to be in the community of free countries of the world where democracy rules. I think that the main duty of the state is to protect and multiply the rules of law, and the state exists for the sake of people, not vice versa. That's why I'm here.
Thank you. I'm your rapporteur, so I'm the first one to ask you some questions, Mr. Chumak. You took part in 2 different selections, one to the Supreme Court and one to the Constitutional Court, 2016-2017. And in 2018, you gave an interview where you explained why your choice was the High Council of Justice. And subsequently, you also submitted documents for the selection in the HCJ. It's correct, huh? And now you're participating in the HQCJ, so that's the 4th one, I would say. In your interview, where you explained that you wanted to be in the High Council of Justice, you didn't mention that in fact you wanted to be in the High Council of Justice, in the High Qualification Commission. So can you explain why now it must be the High Qualification Commission and not the High Council of Justice or the Constitutional Court or the Supreme Court?
Well, definitely I can comment upon this. The point is that when there was the ongoing selection, well, it was not the selection, it was the Congress of Judges selecting the members of the HQCJ, and this cannot be called a competition in context or a selection process. But back then, the High Qualification Commission of Judges was already established, and the members of the HQCJ were elected by the Congress of Judges in 2014. At the same Congress where I was elected to the Council of Judges, which means that I was elected in 2014 to the Council of Judges by the Congress of Judges, and the Commission, or rather a part of the Commission, was also shaped up at that very meeting of the Congress of Judges. That's why, well, that was the procedure enshrined in the law. The Congress of Judges was electing members of the High Council of Justice, and I participate in those procedures. Why I did not participate? Maybe you mean this, the competition that has been the recent competition, where 8 members have been elected. Well, and then if you mean this recent selection, I could tell you that after my experience of participation in the Congress of Judges, and after undertaking all those procedures, when I experienced the selection of members of the HQCJ by the Congress of Judges, well, you know, I'm no longer willing to participate in such procedures because, let me explain you why. Because they resemble kind of bureaucratic activity to me. There must be some negotiation in place. You need to convince someone of something. You need to promise something. There are some agreements, some headquarters. Well, it's kind of an election campaign, I would say. It's more like politics. You have to give some interviews, go on TV, appear on TV as a candidate. It's a rather political activity, I would say, and I'm no longer willing to participate in that. I had this once, I experienced this one, but for me, it's rather difficult to do this. Difficult because if I give promises, whom do I give promises to? The delegates, but I cannot promise what I will not be able to do. The delegates are normally ordinary judges who just want themselves to be protected, and the High Council of Justice for them is the protection body, and of course they would like to hear from the delegates that, okay, I will be protecting you. But in some cases, I cannot give promises like this, and I cannot make certain agreements or start any negotiations in this respect. At least I cannot do this. So for me, it's easier to undergo a procedure like we're having now, when the Commission has the competition, the selection, and you determine who is better, and that's it. It's better for me than the procedure with this Congress. And you know that the selections to the HQCJ and to the HCJ were almost simultaneous, I mean the recent selection. But I decided that the very competences and the mandate of the HQCJ are something which has more to do with me than the ones of the HCJ.
Okay, so I understand because you consider our selection to be more objective, that you decided to participate. That's correct, huh? Do you also agree with the presence of foreigners, you call them foreign experts, in this selection? What do you think of that? And do you feel that it's necessary if you look at the difficulties of the judiciary?
Well, you have already referred to my interview from 2018 or something, the 16th of April. And there was a question asked by a journalist back then. The question was asked in the context of the upcoming competition to the Supreme Court. This was actually after the competition to the Supreme Court and before the competition for the High Anti-Corruption Court. And there was a discussion in the society ongoing then. The discussion concerning the involvement of international experts. It was called back then the Council of International Experts, if I'm not mistaken, in the selection for the High Anti-Corruption Court. There was a discussion whether it's necessary to involve them or whether it would just be enough to have the same procedure as for the Supreme Court. And let me quote myself, because I actually watched this interview once again when getting ready for this interview.
Yeah.
And my answer to the journalist questions concerning involvement of international experts in the selection for the High Anti-Corruption Court was as follows. If we create such a council, meaning the Council of International Experts, then there should be 100% veto, because the current HQCJ will overcome any other veto in case it needs it. And the judges who want to have a fair competition want to have a 100% veto on behalf of foreign experts. The judges, expecting some support from the authorities, feel fine about the HQCJ having the same mandate as it has now. So we can see that my standpoint was developed back then in 2018 as far as objectivity of the criteria of the approach is concerned. This must be done to ensure objective outcomes of the selection. Unfortunately, we are not capable, we have turned out to be incapable of holding objective, 100% objective competitions and selection processes with no interference from some outside parties, for everyone to understand that this is really an objective process and the best people win and not the approved candidates. The ones approved by the authorities win, unfortunately.
Okay. In the same interview, you said, and I quote in English, and I hope the translation is correct, and I'm sorry if it isn't. The problem of trust in the judiciary is greatly exaggerated by the mass media and activists, who for the most part do not understand at all on jurisprudence and fulfill certain political or social orders. I believe you said this, huh?
Well, not literally, but you can ask a question and maybe I will recall. But the wording was not exactly like this, but close to that.
Okay. Is the problem of trust in the judiciary greatly exaggerated?
Well, I would say that this is a comprehensive problem. Not that it is exaggerated. Unfortunately, our situation is as follows. Only negative things are told about the judiciary. And when something goes wrong in the country, you just need someone who would be a scapegoat. And that's why for executive authorities and legislative authorities, the judiciary is the scapegoat. You can always tell that judges are to blame and courts and the judiciary are to blame. But the problems of the country are not only in the judiciary, that's what I mean. denying problems, availability of problems in the judiciary would be a stupid thing to do. Of course, there are problems, and I watched a number of interviews, and I liked the words of one of the candidates who is now in the armed forces of Ukraine, who said that for him, it was also a surprise that servicemen of the unit where he is have distrust and disrespect about judges. That is, I actually, it doesn't mean that I liked the words, but I was frustrated about this. Why so? And the people who are protecting, defending us do not respect the judiciary. So why should courts generally exist if judges are not respected? Well, we may say that there are some representative studies that we are good, in fact, but if we have such a result, well, it's a kind of sounds as a kind of a sentence to us. We should recognize that the judiciary is not trusted by the society. We should accept this. We should stop talking about some studies, surveys, saying that people who come to courts trust courts more. This is not important. Of importance is that the society is generally not trusting us, and that's why we need changes, and that's why we do have the reform going on. And that's why we have this selection in place. And unfortunately, the state, judges, and the judiciary have turned out to be not able to ensure this self-purification.
Okay. And so therefore you say, in fact you say that the judiciary should look in the mirror because of the fact that there is insufficient trust and should not blame others. And the only thing I say about that in your interview at that time, you said that, my translation here, that the lack of trust is made larger because of mass media and activists. And that mass media and activists, they don't know anything really about the judiciary. And that quote clearly gives the blame not to the judiciary itself, but to the outsiders who say to the judiciary, you have a problem, do something about it. So what's your view about it now? Is that you still adhere to the quote that you gave? Or do you believe that it is indeed necessary to change and that the change may have the most effect if the judiciary looks in the mirror themselves?
Well, you know, this interview is about 5 years old. I gave it about 5 years ago. Of course, a lot of things have happened over this period of time. Really, back then, I was among the judges who still hoped for some self-purification process. We hoped that we would be able to ensure this purification in the judiciary on our own, but we failed. That's why we should be looking for new ways. And by the way, the state has been looking for such ways to ensure this purification of the judiciary. And I think that over the recent years, quite a lot of reforms have taking place in favor of the judiciary, and now everything depends only on the judges themselves. The selection to the High Anti-Corruption Court, the Supreme Court, have been conducted. The public, the civil society, is now involved in the selection processes through the PIC and its involvement in the assessment of judges. E-declaration has been introduced by the state. Also, I think that a very substantial reform was automatic case distribution, case allocation in courts. This is the procedure that was introduced, and also the procedure for electing chief judges has become transparent. It used to be not transparent. They were just appointed by some top authorities.
So we made some progress, I understand that. Maybe, in the sake of time, I pass the floor to my dear colleague, Serhii.
No, it's
to you. It's
actually me.
Sorry, Mr. President, it's to you then.
Well, now you mentioned Serhii.
I'll always mention Serhii. I will never forget him.
Пане Сергію, продовження
Okay, Serhii,
з приводу
to
голів
keep
судів.
on with your answer on chief judges. In your motivation letter, you made a reference to two publications made by you in Ukrainska Pravda.
Одна з яких стосується того,
And one of those publications
треба ліквідувати посаду
says
голови
that
суду.
the position of chief judge should be liquidated.
Ви все ще підтримуєте
Do you
цю
still
ідею?
adhere to this point of view? Well, the best support, yes, I do stick to this opinion. And I think that the argument here is that several days ago, one of the candidates, a retired judge who used to be chief judge, told the commission that when he was chief judge, some representatives from the prosecutor's office bodies, some executive authorities, local government bodies, were trying to address him as chief judge for him to help them settle some issues with the judges of his court, asking him to make the judges pass decisions in favor of them. So it means that they were trying to address not the judges, but the chief judge. What does it tell us? That's what I actually wrote in that publication, that the chief judge is a kind of a mediator. All those prosecutors, mayors, seem to still be living in the period of the Soviet Union, and they think that if they are big bosses, the chief judge is also a big boss in court, and he's just going to give an instruction to a judge, and the judge will perform this instruction. That's why they're addressing chief judges. But nobody knows some ordinary judges. Everybody knows chief judges. That's why all mayors, police officers, security service officers, so all the top authorities are addressing chief judges, trying to influence judges by him. Yeah, I have heard your idea. That is a rather drastic suggestion, I would say. But
Поясніть мені, будь ласка, тоді, а як суд
could you
як
then explain to
організація
me
має тоді
how the
функціонувати?
court would be supposed to function as the entity? Even in this small commission, we have the chairman and deputy chairman, though there are only 6 of us. And the court is a very complex entity with many units and departments, with many issues, questions arising. You understand what I mean? So if we remove this position, liquidate this position of chief judge, who's going to represent the court, who is supposed to shape up the agenda? So what about this managerial function if there is no judge, chief judge? Who signs the documents, who puts seals? So what is your idea? You know, Ivan, I've heard the same reservations from chief judges. They claim, and who's going to do our job? Who's going to perform our functions? But what is more important for us? Are those managerial functions more important for us, like placing some seals? Or is it more important for us to ensure the independence of the judiciary? Is it maybe it's more important for us to finally change something? Some chief judges have been chief judges for about 4 or 5 terms of office. You understand what the situation is. Okay, and who should initiate this? Judges or the Verkhovna Rada? Well, it must be a legislative initiative. Of course, the state should initiate this. There must be a political will for that, and I know that there is draft law like this in the Verkhovna Rada. I cannot but ask you about the following thing. Your second publication and your communication with my colleague Robert have some mentions of the Congress of Judges. So what is your assessment of the recent reform of the High Council of Justice? Of course, positively. I have positive assessment of it, which means that everything that was happening was fine. Well, the interviews of the Ethics Council were closed and nobody knows what was happening there, but I hope that everything was fair and transparent. But, well, at least I haven't heard about any claims against the Ethics Council concerning some manipulations or fraud. I haven't heard any claims. I have not been the delegate to the most recent Congress of Judges, so I just hope that everything was fair and that there have been no manipulations. At least I don't have any reservations about this process, and I haven't heard about any. Well, there were some articles, some publications made by some civil society organizations on some candidates who were not clear. They just didn't understand how the candidates passed to the next stage. But it's absolutely okay. I mean, that is the reform of which our competition is a part. We are a part of the element that is being reformed. The state and the society are now trying to build a system in order to revive step by step the trust in the judiciary. New High Council of Justice, new High Qualifications Commission of Judges of Ukraine, new judges of appellate and trial courts, new court decisions of those new judges. And thanks to all those steps, and in particular thanks to all those new decisions, we will gradually have revived trust in the judiciary. That's the way I see it. Thank you. Serhii, it's difficult to say that you're a conformist. Some of your ideas are rather unexpected, original, and even radical in a way. And what about your colleagues? Do they support your ideas? And if yes, then how does it happen? How does it all happen in the judicial environment? Because you say that chief judges opposed to your idea of liquidating the position of chief judges. But do you generally feel that you are supported by judges? I've already mentioned that 4 times I was a delegate to the Congress of Judges, and every new time I'm offered they want me, they put my candidacy again, but I have been there 4 times, so I reject this chance because I think that each colleague should have a chance to see from the inside what the Congress of Judges is like. That's why I will never be a delegate. As far as my ideas are concerned, of course, we have some discussions. In particular, I've got the discussion with one of the former chief judge, but this is just a friendly discussion. I understand what his position is. He used to be a chief judge, and he's thinking really about the mandate, the functions, the placement of a seal. Who's going to do this? But these are practical nuances. And maybe that could be done by a person whose work record is the largest. And every half a year, they should be rotating, not to have this 4 terms in a row in the position of the chief judge, for example, because then the procedures are not very much legitimate. This position is something we need, but these are practical issues only, in most cases. And again, one of the candidates several days ago told what the problem with the chief judges is. That's the example I gave you about the interference into the work of judges via the mediation of the chief judge. And if we don't have this position, we won't have things like that. Of course, if the chief judge is a man of integrity and doesn't have any relationship with any authorities, probably he will not even tell the judge about this influence, but not all judges could really resist this intervention. I don't mean that this should be forever. We should not have this position. But for now, it's like Atroxyl for an intoxicated body. We now need to have some radical reform for now, and then maybe we will change it. You know, in business, it's called an agile structure. Agile, when there is no head, when there is no manager, and when everything is happening on the spot. But you know, not all business has been transformed like that. But the idea is of interest. Thank you, and let me give the floor to my colleague Stephen.
Judge Chumak, thank you for being here and your participation. I read your motivation letter, and it says, the only objective of my participation is to participate in the construction of a new Ukraine in the development of independent, professional, and competent judicial corps of the best lawyers of Ukraine, and as a result, real independence of the judiciary in our country. That would be the commitment that you would go about pursuing every day if you were placed upon the High Qualification Commission. Is that correct?
Yes, obviously, yes. Obviously, yes. There is no other motivation. This is the main one.
But you also say you're not a team player. How would you get your colleagues on the commission to join you? How would you get you can't do it all by yourself. You need other support. What would you do to try to achieve that?
I did not mean that I'm not a team player. Team player in what respect? You know, for 12 years I've been working in the appellate court. I work in the panel consisting of 3 judges, and I don't have any problems. I don't find any real problems with this joint work. I have great relationship within the panel. We reach compromises. We listen to each other's opinions, which means that I know how to work in a team, and I can work in a team. I'm not a sole wolf, just working alone and being responsible for oneself only. If you work in the appellate court, you're responsible not only for yourself, but for 2 judges with whom you are in one panel and with whom you are passing just decisions. But my dream has always been to work in the team of like-minded people for the sake of attainment of some high goal, high objective. And I think that this is the greatest chance to make my dream come true, to do something beautiful, to do something decent you can be proud of at the end of my career. I will know that I've been a part of the team of like-minded people who have the same attitude to the problems of the judiciary we are now discussing, and which are discussed at all of your interviews. I've never said that I'm not a team player. I didn't mean that. Well, maybe I said this, but I didn't mean that I will not work in a team and I don't know how to work in a team. It depends on the team again.
No.
If this is a team supporting status quo, well, I can hardly be a member of such a team. And by the way, I think that this is one of the risks of this selection, that there may be some candidates selected who, to the outer view, don't seem to have any major problems with integrity or professional competence, but unlike agent of changes or game changers, they will be the agents of status quo. And they will be just the players who will tend to play in a different team, the team of status quo. So I think that this is the risk. So in this team of those dark horses and status quo agents, well, I will not be able to work with them quite well. But I will be able to work in the team I have mentioned, the team of like-minded people. And I can listen to people. I can advocate my standpoint, but at the same time, listen to my colleagues if they have good arguments and smart ideas.
You speak of different standards of judges. During your opening remarks, you spoke about the best judges, and you also spoke about approved from the top judges. And I've seen where you've also used the term predefined judges. I'm guessing by predefined and approved from the top judges, you're talking about essentially the same thing. Is that correct?
Well, yes. In fact, this is the same thing.
And of course, my understanding from what you're saying is that you would be looking for the best judges on the High Qualification Commission, right?
Well, sure, this is obvious. Again, one of my dreams is, well, you know, unfortunately, we have nepotism in the Ukrainian judiciary, and not only judiciary. We have this nepotism starting with the Soviet Union period. I don't know whether it's translatable. I think that we don't have a better system than meritocracy. The best people should win, and not the ones whom we could call these predetermined or pre-approved candidates, as you have mentioned, or the ones approved by the top authorities. Even those predetermined candidates are showing themselves and manifesting themselves quite good when the system is rather stable. But when changes come, these predetermined candidates do not actually contribute to the flexibility of the system. The system just collapses because it's not flexible and changes are coming. And the best example of this has been the former composition of the HQCJ, of the High Council of Justice, which in February last year actually terminated its mandate when they had to go to the Ethics Council, and they decided not to do this, and they just quit. They left their job. But 3 people still went there, and they work now. They keep working. They have passed this selection. So this is the challenge. For over a year, the HCJ, because some of its people terminated their mandate and left, could not be working. I mean, there were a lot of problems because judges could not get dismissed, could not be transferred, could not be re-elected. So nothing was possible. But 3 judges, seems to me these were all the judges, yes, 3 judges still decided to go there. So they were decent enough not to stop working. So this is the criteria, the indicator that shows us that at a certain point of time, the system is either going to collapse or no, depending on whether it has flexibility or no. So these people, status quo people, will just not be flexible.
In the last 2 days, I've heard the same term twice from different candidates. They spoke about the concept of judicial solidarity. I don't know if that's just a term that they've derived informally or if it has some more understandable meaning, but what does judicial solidarity communicate to you as a concept? Have you heard the term before? Does it communicate anything of particular that you understand?
Well, I haven't heard it as a term, judicial solidarity. I've just heard corporate solidarity, but I know what you're talking about. That judges are actually trying to hiding the sins of each other. I don't think that it is the case now. Maybe it used to be the case. The judiciary was kind of a closed corporation. But I think that it's not true that much as for now. It's not very much relevant. And for example, we may take the High Anti-Corruption Court, where judges are judging other judges. And we know that there are a lot of sentences that have already been made against other judges with real punishment. So this has ruined the system of judicial solidarity. I don't see it now. I don't see any manifestations of it.
Judge, I think you...
Well, General, of course, I can speak only about myself and what I see around me, but still.
Let me interrupt you for a moment there. I think I'm pretty clear on your mission, your ambitions, your objectives, the standards you would apply. But obviously, we're looking for an effective commission to pursue and to reach whatever mission has been established. My question is, you have been on past selection commissions. You're now involved in this selection commission process. What have you learned from these processes that you think are necessary to either avoid or to try to adopt in some way or to improve upon in some way so that the high qualification commission selection process perhaps with you on it, will be as successful as it possibly can be, as effective as it can be.
Thank you for the question. I'm not a supporter of change for the sake of change or reform for the sake of reform, so that we find ourselves in a state of constant reforms. We need to put a full stop to the reforms at a certain point in time. In order to understand what needs to be done, we need to analyze the past, the work of the previous HQCJ. Of course, the Commission did a great deal of work. They approved the regulations, they developed the methodology for the assessment, so they didn't really have significant problems with achieving the results. But, as I've already mentioned, the Commission did not enjoy the trust, neither on the part of the society, neither from the government or the judges themselves. So the main problem of the Commission was its dependence on the executive government. That's what I believe, at least. And all the other faults, which we consider to be faults or drawbacks, were actually those choices made by the HQCJ. So there was a causation relation there, because the Commission was dependent on the executive government, and those complaints made against the Commission had to do with the selection of winners when selecting trial court judges at the very stage of the selection. Why did we have those complaints? Because the Commission, in order to have this subjective influence, chose to have this great deal of discretion when assessing the candidates. Let me provide a small example. During the first selection to the Supreme Court of Ukraine, the selection in which I participated. So between the first position in the ranking and 179th position, there was some 250 points used by the Commission for the discretion. But the difference between the first spot and 173rd spot was just 53 points. So they were using this subjective influence, this ability to have the subjective influence. And in my opinion, that actually resulted in some manipulations when a person from the place which used to be 102nd somehow was selected to be appointed as judge of the Supreme Court, and the Commission had to explain why was the person that outstanding. What was it that they demonstrated during the interview that they made that huge leap from 102nd place to the 29th or 27th? The Commission did not explain their reasoning. Lack of transparency and subjectivity, this great deal of discretion, gave the Commission a lot of power. And the Commission abused that discretion, and we have to eliminate it. We need to diminish this subjective influence. I have some suggestions on how it could be done, but it will take another couple of minutes if you want me to continue.
No, I think we better move on here, but we definitely appreciate what you have to say. Let me move on to my colleague, Judge Serhii, please. Thank you again.
Judge Chumak, let me pick up on your discussion with my colleague. There has been a suggestion similar to the one that you make, that is that the subjective judgment that exists as part of any selection process should be kept to a minimum in the case of the HQCJ. That's an interesting observation and/or suggestion, but every candidate that we have heard from, including yourself, tells us why, with their background and their history and their experience in the law and their values and their motivation, they should be appointed as a member of the HQCJ. Now, it seems to me that there is an inherent contradiction that arises here. On the one hand, candidates are advancing their qualifications to be appointed, and on the other hand, the use of those qualifications, the knowledge, the experience, is inherent in the subjective component of selection. That's why we have paid so much attention to people's experience and their qualifications and their motivation. So is there any room left in the work of the HQCJ that will engage that experience, the education, the qualifications, the past history of a candidate or now a member of the HQCJ in the work of the HQCJ? Or is it all going to be mechanical? Is it all going to be empirical? Is there any room for judgment left?
In view of those problems that I've already mentioned, inherent in the work of the previous HQCJ, I would suggest that at this stage, we should minimize the subjective power. But I understand it cannot be done for 100%, of course. But it's my suggestion to minimize the discretion. I understand that there is a certain degree of discretion that will be left. But at this very stage, I think we must eliminate it as much as possible. Let's look at this example. What are those stages of the selection that cause the least questions from the society? This is the stage of the testing and the anonymous practical assignment. Practically nobody, with some exceptions, has complaints with regards to these stages. Why? Because there is no subjective influence of the commission members at these stages. And all the complaints arise during the stage of the interview. And the transparency in the activities of the commission lies not in trying just to show this transparency by broadcasting interviews, but then the commissioners closed the doors and they had their discussions and they decided how to allocate those 250 points for integrity. I think that right now it's important to eliminate discretion. Regardless of how professional, great people those candidates that you are going to select are going to be, a human being is not black and white. There are multiple hues to us as people, so there is always room for some subjective factors. If there are no safeguards, then even the best of people can, with their subjective opinion, maybe they simply disliked someone. Maybe there was something else. Maybe they were in a bad mood. They didn't have enough sleep at night. So we are all human beings. We are all prone to some weaknesses. So I would still eliminate any subjective factors. When we are assessing integrity, I would elevate the status of PIC to eliminate the subjectivity. It's just one of the proposals. So we should follow the principle of presumption of integrity. So all the candidates should be given 250 points from start. And then when we have the opinion of PIC, the negative opinions of PIC, then we set interviews with those candidates. And based on the interviews, we either override the negative opinion or not. If the negative opinion is overridden, then the candidate gets 250 points. If they do not manage to dispel any doubts, then they get a 0 for integrity. I don't think that we can score integrity by giving 50, 55, or 100 points, 150. We cannot give scores to integrity.
Yes. Now, just.
So let's just eliminate the subjective factor.
Now, if we eliminate the subjective factor, what differentiates one candidate to our selection commission from another? They can score, the examination will be scored, the practical task will be scored, usually by outside parties, like the National School of Justice and its volunteers. And the psychologists will, of course, provide their opinion after the interview of candidates. There's really no point in having interviews of candidates if there is no resultant opinion that is formed from those interviews. So where is a candidate's qualifications and his experience and his education, where does that come into the process, in the process that you are describing? One of the criticisms that we have heard, or put another way, one of the suggestions that has been advanced, is that the problem with the subjective allocation of the 250 points was the fact that there was not a reasoned decision that would support the conclusion that was reached. And therefore, there is still a considerable amount of room for subjectivity opinions, that is to say, the use of the HQC members' knowledge, experience, and good judgment, so long as it is properly reasoned, so that an outside observer, an objective observer, can reach a decision about the integrity, if you like, of that analysis. So, as I say, your model would seem to eliminate the benefit that can be received by the HQCJ from people like yourself, who has the knowledge, the education, the experience, and has spent so many years of your life exercising judgment. That is what the judicial function is all about, the exercise of judgment. So, I invite you to respond.
I'm familiar with the practice of the Supreme Court on the review of the decisions of HQCJ, and I know that one of the main problems was lack of reasoning of the decisions made by HQCJ. In particular, in part of giving scores and also absence of a detailed scoring scale for each of the criteria that are being assessed. Frankly speaking, I have a hard time thinking how to develop this kind of scale. So I was listening to some of the candidates, and they said that in order to minimize the discretion, we need to have this table with scores. So you have the maximum of 250, and if you have some mistakes on your declaration, we deduce 10 points. If you have another mistake, then minus 20 points, and so on and so forth. So I do agree with this proposal, but the problem here is that we will not be able to foresee all the possible violations. And then when we have this gap or this blank spot, that we will not know what to do because it will not be there in our scale or on our table, we will be faced with the dilemma on what to do with this candidate because it's not foreseen by this scale of scores. We can try and do something about it, but it may involve some problems. So with me saying that we need to eliminate discretion altogether, well, I think that in any case, the Commission will be considering the opinions of PIC, and this is where the Commission will still have its discretion. Whether the Commission will be able to override those decisions or not. And in the course of the interview, those concerns expressed by the civil society will be voiced. Maybe it's going to be a joint meeting during which the candidate will try and convince the HQCJ and PIC that it was a mistake, that the circumstances were different, and based on the results of that meeting, the Commission will arrive at their decisions. So this is where we still have some level of discretion. As I told you, we cannot eliminate discretion by 100%, but during the stages of testing, exams, psychological evaluation, I think that we could still score these things, just give scores and not use that much of our discretion when we are writing our opinions. And when the society doesn't see any reasoning behind the decisions made.
All right, thank you, Judge Chumak. I'm going to turn you over to my colleague, Judge Mezentsev.
Thank you, Dad. Пане Сергію, доброго дня.
Good afternoon, Serhii.
Мені чомусь часто випадає дуже приємна
Well, I'm often entrusted with the not very pleasant role of asking questions about property and assets, but I believe that in any case we have to do that because our selection is transparent and we have to discuss the problematic issues out loud. So the first question I want to ask you, you have provided your explanations already, but we need to discuss that in public. In the year 2016, your wife bought an apartment in the city of Dnipro. The price of the apartment was equivalent to $28,000 US dollars. And we have received information that apartments in the same neighborhood can be having a price which is twice or even 3 times as high. Could you please explain this price? You have a mistake that the apartment was bought in 2016. No. It's about the declaration that you filed in 2016, in which you mentioned this asset. Yes, so it was the year 2015 when in May I was transferred to Dnipropetrovsk Appellate Court, and my family and I needed an apartment. We first rented an apartment, and then we decided to buy an apartment. It was the choice that my wife and I made that we didn't want to rent any other apartment, so we decided to buy one for us. And we started looking for the cheapest apartment, an apartment that was not renovated, that required additional renovations. As I've already explained, the value of this apartment can be proven by the appraisal results, which are indicated in the sale and purchase agreement, and the appraiser mentioned that the value that I indicated in the declaration complies with the appraisal value. I have no involvement in the appraisal because it was commissioned actually by the seller of that apartment. And number two, as I already mentioned, we did some renovations in the apartment. It's a building built in 1970s, so we bought it in the condition that it had since it was built. So we practically replaced everything in that apartment, and we spent approximately $15,000 on renovations. Plus, we spent another $3,000 to buy home appliances, because we were unable to bring the home appliances that we had at our previous apartment. So, in fact, the apartment cost $25,000, which practically corresponds to the value. So I read the information that I was provided with, and that value of $25,000 practically corresponds to the value of those apartments that the civil society organizations are referring to. But again, they mentioned some apartments that already had renovations, home appliances, and if one bought an apartment like that, they wouldn't need to additionally invest. Yes, that's clear. Thank you. Let me add just a couple of things. I just want to explain to our audience. And in the explanations, I also mentioned that I mentioned the income of my wife and I. No, it's not the doubt that we are having in your level of income. It's just about the price that was indicated for the apartment. So we did have the income. We could buy an apartment for $20,000, $30,000, or even $40,000. I don't see any corruption risks in that. So you used to be a member of the Council of Judges of Ukraine. At that time, the mandate of the Council of Judges used to be wider than we are currently having, according to the law on the judiciary and the status of judges. In your opinion, do you think is it necessary to enhance the level of competence for the Council of Judges of Ukraine? And if yes, in what aspects? And if no, then could you please explain? The mandate that the Council of Judges currently has allows for them to make some decisions that have an impact on the development of the judiciary. Yes, I agree with you, but do we need to expand on that mandate, or maybe we can keep the mandate as it is, or maybe even narrow it down? So it's a body of the judicial self-governance. We shouldn't be eliminating the Council of Judges. Why? But you don't see a need to expand on the mandate. Maybe it would be feasible, but I've not been a member of the Council of Judges for 7 years, and frankly speaking, I did not give any of my consideration to that question. Thank you. Thank you. With that, I'm passing the floor to Serhii. Good afternoon, Serhii.
Значить, дивіться, я хотів би повернутися до запитання,
So I'd like to go back
яке вам задавав
to
суддя
the
Маркман,
question
а
that you were
саме
asked
щодо
by Justice
командного
Markman
гравця. І на це
about
запитання
being
ви
a team
пояснили,
player.
що ви готові бути
And
частиною
in
команди
answer to that
однодумців.
question, you mentioned that you were ready to be a part of a team of like-minded people. And you said that if the team was not made up of like-minded people, then it meant that some of them were agents of the status quo, not agents of change.
Безпосередньо виконання тих повноважень,
The
які покладені на
HQCJ
неї,
is going to be acting within its mandate. And if in the course of the decision making, so let's assume you are appointed as an HQCJ member, and in the process of decision making, you hear that one of the members does not agree with you. Does it mean that he's not an agent of change?
Виходячи з того, що ви сказали, я хотів би
So
просто
I'm making
уточнити.
this conclusion based on what you've said. Let me just clarify this. I would like to repeat the things that I've mentioned. I don't think that I'm always right. I'm going to listen to the opinions of other people. I acknowledge my mistakes.
Ну, я
I
зрозумів.
have the
Тобто ви
experience of
прислухаєтеся,
working within a
можливо,
team.
до
Okay, that's
думки
clear. So
колеги,
you're
які
going to
ви-
listen to the opinion of your colleague. I don't have any problems with ambitions. I'm not saying that my opinion is the only correct opinion.
І ще
Thank
хотів,
you, that's
два
clear.
запитання з вами,
And one more question.
з'ясувати. Ви поясняли про те, що це здається на запитання пана Роберта.
So while answering
З приводу
Robert's
того,
question,
що ви з приводу високого рівня недовіри суспільства до
you mentioned low level of trust in the judiciary.
не спрацює принцип
And you
самоочищення.
said that the principle of self-cleanse will unfortunately will not be successful. But what do we do with the incumbent judges?
Виходячи з того, що ви сказали, от в
Just
даному
on the basis of what you said in this specific case. What I meant while answering this question was the bodies for which we are now having selection processes and which are now in the making and for which the procedures have been changed. These are the Constitutional Court, the HQCJ, and the HCJ. Thank you, Serhii. No more questions. Let me give the floor to the chairman of the commission, Ivan Mishchenko. Thank you. Are there any further questions to the candidate?
Пане Сергію, наша
So, Serhii, our interview
прямує до
is about to finish,
і ми надаємо вам можливість її підсумувати.
and we give you an opportunity to sum it up again and to tell the core things you would like to stress or probably have missed something in the course of the Q&A session. So the floor is yours. Yes, an hour and 15 minutes have passed too quickly. I've just had a look at the clock and I haven't realized that we have discussed a lot of things, but we have also not touched upon a lot of things because of lack of time. In my concluding speech, I would like to say that the country where I live, Ukraine, has given me everything I have. It has given me life, my family, my daughter, my job. And there is time to scatter stones and there is time to collect stones. So I think that my state has invested into me as into a professional, into a judge, a human being, an individual, and now it's time that I pay it all back to the country. A judge is a kind of a sole wolf responsible for himself and his decisions, but let me repeat that I have been dreaming all my life long about having a team of like-minded people with whom together we'll work towards a high goal. I hope that in 10, 15 years, when Ukraine is a prosperous, independent country, the same as the judiciary, and when my generation is already leaving, I will really be proud of having participated in this process of change. And the Qualification Commission, in which I had the pleasure and honor to work, also made its contribution. Thank you. Glory to Ukraine. Let the best people win in this election. Glory to heroes. Thank you, Serhii. So our interview is over.
Всього вам найкращого.
Good luck to you. Stay safe and goodbye. Goodbye.